So we have, as I gather, a relatively narrow focus for our task, which I think is good. We're primarily focused, I think, on localized shared automation. That is SAE level 4 in particular applications. And there are other areas we could talk about, but by and large, we're looking at systems that are capable of driving themselves under a limited set of conditions. This is the operational design domain, or ODD, that you've already heard about. Will not go everywhere all the time under any conditions, because that's way out there, but will be capable of operating without a driver, and that's very important because that enables automation. Because these are limited to particular domains, we can start speaking of location-specific deployments and specific communities and municipalities and regions that could oversee these. And this matters when we start talking about law and policy. We do not necessarily need to solve everything all at once for the whole world for time immemorial to make some things happen soon and happen actually on the ground. And this is where law and policy can get really confusing really fast. We have the dimensions of time and space. Math, for all its complexity, was not different 5 or 10 years ago than it is today. It is not different in China than it is in the United States. But law varies dramatically, and it changes. It changes, and sometimes slowly, sometimes quite dramatically. And so speaking in generalities about law is very difficult and sometimes not even all that productive, because you end up at levels of abstraction that can't be credibly implemented into local legal systems. Also, when we speak about law, there's a temptation to start confusing a few different views. I speak of the descriptive, predictive, and the normative. So the descriptive is, what is law today? If we were going to open up a book of code, if we were to review a bunch of cases, what would the law say today? How would that law apply to the technologies and applications under discussion? That is different from asking, what will law be like in a year, 2 or 5 years if we do nothing? For engineers, that's the no-build case. If government does nothing, what will the world of tomorrow look like? Likewise, if lawmakers do nothing, how will law nonetheless change and evolve? Or if this group does nothing, how might lawmakers absent our guidance improve or mess things up? And then the third is the normative. What should happen? What do we want to change? How would we remake the world large or small if given the choice? And these are all different discussions and require different levels of humility and vision. I am all for the bold approaches typified by a normative view, but I think we need to start with a more modest view of, well, what can happen without us and what will likely happen. So what can governments do, first of all? As I described in the paper, there are a range of government activities, some of which often get overshadowed by others. So governments at a foundational level can monitor. They can monitor the state of the technologies. They can monitor the deployment of those technologies so that they understand what vehicles are actually on the road, what levels of automation are actually deployed. They can educate the public. Jane had mentioned the importance of consumer acceptance. I have a particularized view on that, but it's certainly true that the broader public context will shape the way in which laws are interpreted and made and the technologies deployed. Governments necessarily will react. This is where they don't have a choice. They will react to lobbying by companies. They will react to crashes or other incidents that occur, and they will necessarily need to adjudicate the court cases that arise. And this is why preparing another government function is so important, to make sure that the right institutions and communication systems are in place, that agencies have the resources and the skills in order to anticipate and then to react to what happens in the field. When we start getting into the details of law, descriptively and predictively, there is a lot of uncertainty. Some laws arguably are very consistent with automated driving. In the case of the Geneva Convention, if not the Vienna Convention on road traffic, there's a very credible argument that nothing needs to change in that treaty. There's a credible argument that dramatic changes need to be made. So government can also clarify the application or the meaning of existing law in the context of automated driving to provide clear guideposts for developers that are looking to implement or developers that are looking to change that law. Restricting is the most classic function of regulation, and for reasons that are unclear to me, the goal of restricting automation seems to have been conflated in at least some jurisdictions with the idea of promoting it. That we'll have legislators or regulators that say, well, automated driving sounds really great, we want to help it along, so we'll pass a law that makes it harder to do. That seems a little counterproductive to me, and yet that's been the approach of some jurisdictions and the tendency, I think, of agencies that do traditionally regulate as a first function. But nonetheless, there may be a role for restricting particular activities or actors or applications. The core of, I think, this meeting is really promoting automated driving, or promoting a reasonable implementation thereof. And there are a range of strategies that governments can take there. And finally, and I would say almost most importantly, is planning, is stepping back and saying, not how do we get the technology, but what is the world that we envision, much broader than merely automated driving, far more broader than just driving, and how do we use all of these technologies to get us there? And that's where government is particularly well suited to act, because at the same time that governments are or are not undertaking all of these activities, developers in the private sector may be acting as well. There are incentives for the private sector to analyze existing law, figure out what it means, and if that meaning is either unclear or unfavorable, to push for specific legal changes. Any of the companies that want to make money in the sector realize that not only do they need to develop their technologies, they need to develop the law in a way that is conducive to them. And so, while government needs to be able to ask the right questions about that, I'm not too concerned about us all coming up with the perfect regime today, because there will be enough private incentive to at least provide the legwork for that. But there's much less money to be made by figuring out how to deal with massive unemployment, by figuring out how to deal with dramatic changes that go far beyond driving to education and land use and socioeconomic considerations and equality that implicate automated driving, but that aren't quite as lucrative or frankly as sexy as a self-driving car. And so this is where government has, I think, a particular obligation and really opportunity to influence this discussion. I mentioned that developers are acting. Developers, like governments, are not all alike. The ride-sharing, and excuse me for my terminology, I realize I should share the broader sharing economy that we've seen points to different levels of risk tolerance and aggression among the private sector. Some companies promoting automated driving are going to decide that they do not want to act until there is a very specific, clear legal framework in place that preferably conforms to their particular vision for automated driving. And to the extent that they feel that the current one is inconsistent with that, they will push for specific legal changes. Already we're seeing this in the US, in some states where a few key companies have been very influential. In some degree in countries where particular industries or companies are very closely associated with a national or a regional government, there is that close cooperation. Some developers will be a little more comfortable with uncertainty, will probably be more comfortable waiting until they have a particular vision of what they want before pushing for any specific codification of that vision. And then some are going to be perfectly comfortable operating in the legal gray area or pushing the line of what is legal or accepted or acceptable. And these are companies that exist today that will still be there tomorrow, as well as many that may not have the constraints we typically see, whether those are legal or reputational or liability related, that might inhibit them from acting aggressively. And I'm speaking in vague terms, but when we get into the general discussion, I'm happy to throw out some names of those companies that might epitomize each of those philosophies. And so an approach to law needs to account as well for all of the ways in which different aspects of the private sector can and will engage with that legal infrastructure. Well, I mentioned that one of the key functions of government is or may be to promote these technologies in socially desirable ways. One of my papers has about 50 strategies for the way that governments can do that. And I won't go through all 50 now. What I will say is that many of them boil down to economics, to internalizing today's externalities associated with driving, so that automated driving, to the extent it actually is safer or more time efficient or more space efficient, can compete and compete well against conventional technologies. So what do I mean? Well, today, even in many European countries, depending on the numbers you use, the cost of a liter of gas does not fully account for all of the costs imposed by driving to burn that liter of gasoline. And so driving is subsidized. If people paid the full cost of that driving, then automated driving, if it was more efficient on a per kilometer basis, could compete with that driving. People do not necessarily bear the full costs in advance of crashes, of their driving behaviors. If insurance costs fully reflected those, then driving would be more expensive, and automated driving, to the extent that it was actually safer, would seem more attractive. Likewise, parking. People who park at their homes, park at their offices, do not pay the full cost for all of that parking infrastructure, are going to be inclined toward an individualized model. But if they bear those full costs, then automated driving, to the extent it facilitates sharing and eliminates some parking needs, will seem more favorable in comparison. So by making driving today, frankly, more unpleasant and expensive, we can make automated driving more attractive in the future for good reasons. Now, the upshot of this, or the downside of this, is that I'm describing a world in which we're making life even harder on the poor, particularly the rural poor, who may rely on driving because there is no other choice, who are going to be driving unsafe older cars, who are going to be very unhappy at the prospect of paying more for a liter of gas or a parking space or a toll to get into the city. And this is why I return to the notion of planning, that engaging with responses for promoting automated driving necessarily requires thinking more broadly about the world that we want to create. Thinking about how we address these broader questions of socioeconomic impact, not just of automated driving, but of all of the technologies that are coming and all of the impacts they can have. How we design a land use policy that encourages density not just for the wealthy, but also for the poor. An education system that provides the proper incentives for people to locate in places where they can still have good education for their children. All of these are within the sphere of automated driving and belong in the discussion. So the question of where does the conversation take place in government? This was a question that was asked this morning, is immensely important. This is not a discussion that should be located only in an agency responsible for registering and regulating vehicles, not just in an agency responsible for building roads, but really all agencies responsible for thinking about how we serve the public. So I got really broad, really fast, because it's important, but let me return to a few specific points that I addressed in my paper for this workshop and that I hope we can discuss as later. First is this tension between harmonization and standardization on one side and what I would call customization on the other. There is understandably a push to not make the mistakes we made 100 years ago in the introduction of vehicles. We don't want a future where some countries are driving on the left, some are driving on the right, as an analogy for automated driving. But we're also not dealing with physical infrastructure in the same way that we were 100 years ago. We're not going to have an instance where a country will need to dramatically change over the direction of travel. And so the fact that we're dealing with technologies that can be updated, with infrastructure that is at least part digital, gives greater flexibility in the future to harmonize on what works well, to figure out through local experimentation what works, what doesn't, and then apply that more broadly. In other words, we might be allowed to get it wrong in small ways for a little bit before we universally try to get it right. In approaching specific legal regimes, there are a few strategies that governments can take. This is individually or in coordination. The first is to redraft entire regimes, to say automation fundamentally changes the way that rules of the road should operate, the way that vehicle regulation generally should operate. Therefore, we should modify the entire legal code to treat automated and conventional driving essentially the same and have one set of rules that apply to them all. I like this as an exercise in harmonization because it takes us beyond just automated driving into the underlying legal regimes that are still so variant among countries and within countries. So looking at rules of insurance, looking at vehicle regulations generally, looking at processes of approval. These are areas where generalized harmonization would be useful, even if we're not speaking about automated driving. But this is also a lot of work to redraft an entire regime. Another approach is to replace that regime, to say essentially we're taking conventional driving, setting that to the side, wiping the slate clean for something we're going to call automated driving, and coming up with a nice, clean, simple, small set of rules that works for it. This is the approach we've seen in some cases in the transportation network company ride-sharing context, the B2C that you spoke about, where companies, for better or worse, have convinced us that they're doing something entirely new and they need a new set of rules, and therefore we should craft that without regard to what they're replacing or competing with, i.e. the taxi. This might be useful. This is especially appropriate for the kinds of localized shared automation systems that I think are most of interest for this workshop, because they will be, at least initially, constrained in some ways, including by geography. We can come up with a package solution that might work in an area of deployment, apply that, and then move on. And finally, the third approach is reconciling, to try to come up with legal rules and interpretive guides that map existing law onto these new technologies. The best example of this is the identity, the legal identity of the driver or operator or Fahrzeugbehalter or any of the terms we want to use to describe this person most closely associated with the operation of the vehicle. We can say who that should be in the context of automated driving, but more importantly for these kinds of localized deployments, we should also say who it is not, so that an ordinary user of one of these vehicles, someone who is really no more than a passenger, can ride without concern that they will need insurance or that the whole host of traffic laws will in some way apply to them. And so this negative definition is as important as the affirmative definition, but it's been, in my experience, lacking in most of the legislative enactments. So the second area is testing versus deployment. I've warned about this for years, that we're drawing this false dichotomy between what's clearly testing and what's clearly deployment, when in fact most of the innovation, deployment, and even utility will be in a gray area that falls somewhere between. Whether that's over-the-air updates or field operational tests or pilots or betas or things that aren't betas but they just get called betas for years afterwards because there are strategic, promotional, or even legal reasons for doing so. I don't know, is Gmail still in beta or did they finally ditch that? This is what we're talking about, that we're moving into a world of physical devices that in some ways will draw from the world of purely digital applications, where there is no fixed date of implementation, there is no certainty, and there's always the option to update or change. This isn't as big of a departure as we might initially think, because today's products aren't perfect. As much as we'd like to think that today's system works in every way, it doesn't. We regularly have recalls, we regularly have issues that arise as people learn more from the real world environment. And that will happen here too. Again, the location-specific deployments that are most compatible with shared automation lend themselves well to this middle ground, to defining a particular operating regime that falls somewhere in the middle of testing and deployment and looking more at the risks rather than at the particular labels that might apply. And finally, as in law generally, there is a tension between flexibility and certainty. If we left today with one set of universal rules for what automation is and how it should be deployed, we would create a great deal of certainty. We would also foreclose potential applications, business cases, and innovations that we could never think of today. And that's where the flexibility of law is important to preserving this room for innovation, for technical innovation, and even for regulatory innovation. Part of that is accepting geographic discrepancy, accepting that we might not have one rule fits all immediately. Part of it is also accepting that law can and should evolve, and there should be mechanisms for fostering that evolution. One of the proposals that I've pushed very aggressively is the idea of a public safety case. Rather than telling developers exactly what they need to design and exactly how they need to demonstrate the safety of what they have designed, the public safety case would invite, and under some cases maybe even compel, these developers to come forward with their safety philosophies, to say how they define reasonable safety, how they measure it, and how they will continue to monitor it for the lifetime of their systems. This is important because we are moving from a world in which we focus on products to one in which we focus on not just services but activity, the testing and development activities of particular companies, the ride sharing or automation activities of particular public or private actors. And so, as much as we might like to establish trust in specific products, the more practical focus might be looking at ways to establish trust in the developers and the deployers of those products, so that we can say the people who are putting these vehicles on the road, the entities that are operating these shared networks, are deserving of our public trust. And here is why. That provides certainty to the public in the form of credibility and trust, but flexibility to those developers so that they can continue to innovate not just in technology, but also in models of earning that trust. So I would welcome any of your questions now, and I look forward to the discussion. Yes, please.
Yeah, go ahead. I just a question to what your thoughts are on enforcement of the Highway Traffic Act and autonomous vehicles. The Minister of Ontario, or Ministry of Ontario, recently announced a pilot project, 3 vehicles, and the Minister, or the Minister's representative said, and of course they'll follow the Highway Traffic Act. At the same time, next weekend, I was driving from Toronto to the Laurentians at 120 kilometers per hour, and I was going the slowest on the road. A vehicle going 100 kilometers an hour would be a danger.
Yeah, and this is where I say we need to expect more, not just from automated vehicles, but from all vehicles and their users. It goes back to what kind of world we want. Do we want one where we flout speed limits or not? If we decide that we don't, then there are means of enforcing traffic laws today. Use speed cameras, use automated enforcement. Ontario was a leader in governors on trucks for the purpose of speed. There are solutions that address non-compliance by conventional users. If everyone figures out that they cannot speed, then automated driving will look even more attractive in comparison. And so that's where I would focus attention, raising the playing field rather than leveling it by in some way lowering it for automated driving. Yeah, thank you. Yeah, Natasha.
I liked your last sentence around trust. First, do you really think that any organisation is going to say trust this particular company rather than another one? I mean, how will that be built, and how will what do you think it will happen if actually it ends up causing an accident?
Yeah. So this is a really important function of government. As much as government gets denigrated, and we're in an environment where that's happening even more. Nonetheless, people have certain expectations of their government, and implicit in that is some notion of trust. And so government can convey credibility to activities, to services, and to developers. I don't envision a seal of approval, A+ company. There is negative trust, saying these entities have clearly failed the public trust. The only death penalty I believe in is for companies. But it's also setting up processes and public fora for companies themselves to establish that trust, to say this is what we're doing, here are our data that support what we're doing, and here are our responses to the public critiques that we've received of our approach. And that's where government can build trust, through those fora and processes and mechanisms rather than an arbitrary stamp.
I think we're going to have to move on because we're falling a little bit behind schedule. But yeah, thank you, Brian.
Oh, thank you.